Welcome to the Lead Clinic podcast. I'm your host, Dr. Peter Vitale, and today I'm joined with a very special guest, the Czar of the TCPA, Eric Troutman. Good to have you, Eric.
Hey, fantastic to be here, man. Thanks for coming out to our studio, actually, and shooting. I guess this is like at my home territory and away from yours, so I appreciate that.
It is, of course, yeah, and a beautiful office you have. And for those of you, this is probably a different crowd than you're used to speaking to, right? This is not really lead gen folks, but primarily insurance agents that use lead gen and support lead gen, or use lead gen to support their businesses every day. And,
Sure.
For those of you who don't know Eric, right, he is the foremost expert on the Telephone Consumer Protection Act and kind of all things marketing compliance, and has really, you've really done a great job at being probably the number one, defense attorney in that space. And that's a huge thing. So just give us a brief overview. How'd you get into this?
Yeah, I can give you the brief version or the long version. So look, I've been doing nothing but basically TCPA related, telemarketing, advertising law for the last 13 years of my career. And I started off actually doing the work for major banks and finance companies. And it actually wasn't around marketing. It was around their outreach for informational messaging, debt collection, servicing, or transactional texts. For instance, you go to an ATM and you ask to get a text message sent to you to confirm the deposit. And these text messages would go to the wrong number. And there'd be these massive class actions filed against Wells Fargo or Ally Financial or US Bank, all of whom were my clients. And I would just, I would defend them because these cases were ridiculous. And over time, we were actually successful both in courts, but also with our clients to kind of clean up their operations. And wouldn't you know it, I kind of put myself out of business. And so I had to find new clients. And so what ended up happening was we pivoted from the transactional messaging more into the origination and the marketing side, first of the big finance companies. And what we found was most of the cases were being driven by allegations, at least, that the leads that they were buying were fraudulent. In other words, the plaintiffs they weren't saying, oh, you don't have a lead. What they were saying is, you have a lead, but I wasn't the one that went to the website. And once I started seeing that, I realized I had to get deeper into the lead generation industry. And I'm sure we'll get to that if you'd like. But we've really tried to be agents to affect change, to clean up some of this bad behavior.
And we know that there historically has been a lot of bad behavior in the lead gen space, right? The folks who are going to be watching this podcast are the exact people that we talk about all the time that don't have any use for those fraudulent leads at all, right?
No one does.
Right?
No one does.
Exactly.
Yeah.
What do you think the most egregious thing you've seen so far in lead gen has been, or one of the most egregious things? And tell us a little bit about what you're doing to try and stop that, and what insurance agents can do better, and how they can, be better lead buyers in this system.
Well, you got 5 questions then.
I know.
I'll try to take them kind of piece by piece. Well, so I can't tell you the most egregious things I've seen because there's a lot of privileged information there.
Sure.
But I will say, I think Rich Kahn's data, he's the guy from Anura, that says up to 30% of leads are fraud. And by fraud, I mean literally made up, concocted. Someone used a bot, someone used a click farm to, fill out a form on behalf of a consumer. I just think that's a staggering statistic.
It's a lot.
30%. Are you kidding me?
Yeah, it's a lot.
3 out of every 10 leads you buy is fraud. That, to me, that is egregious. You don't have to go past that and talk about anecdotes. That is just staggering to me. But just since we're on anecdotes, when I started going to, your affiliate summit, your leads conferences, LeadsCon, specifically to talk to the people that were selling leads to my client, right? Mm-hmm. So I would go down there, on behalf of Loan Depot, let's say, as their outside counsel, and I would literally go booth to booth at the ones that I knew were selling leads to my clients, and I would basically be like, look, I'm the sheriff, okay? I am counsel for the brand that you are selling leads to, and I'm here to make sure that you are on the up and up. And most of these folks are straighten up and oh, absolutely, we're very compliant. But so pervasive was the misconduct at one time in this industry that I can remember very clearly a couple of people just saying, whatever, we don't follow the law all the time. We're a gray hat. We don't pretend that we're a white hat. We're a gray hat, and we sell data, and if people buy it, they buy it. And I just remember thinking, this is horrible. They're not even pretending that they're trying to be compliant. And that's the marketplace that lives out there for leads, is at least, and that was at least the case 2 years ago. Now, I think Pooja and I have been very forceful with the industry, getting aligned with an existing trade organization, speaking at every conference I can speak at, and really pushing home the idea that compliance has to be critical. And we really started that conversation within the industry, and we did affect change. I like to say I'm the guy that stopped more robocalls than any other human being alive because of the work I did both for the banking industry and then for the lead gen industry. But ultimately, it was still small potatoes compared to what we did with Reach, which, we're leading up to here. But we definitely tried to get through the existing trade organizations, the existing apparatus that existed within this industry to try to get them to take this more seriously. It was only when that effort categorically failed that we decided we had to take matters into our own hands.
And so tell us what Reach is and what Reach stands for and kind of what we're looking to do with Reach and how your grand vision for it, I would say.
Yeah, so we're talking about responsible enterprises against consumer harassment, right? That's the name of the organization. It's a California Mutual Benefit Corporation, which doesn't really matter, except that we're empowered to both advocate on behalf of industry and also get industry members aligned behind standards. And so it's kind of a dual hat. We're doing multiple things with Reach. So the idea spun out of my frustration, as I just laid out, with the existing apparatus, the existing trade organizations within the lead generation industry having no interest, in my view, none, to actually clean things up. It was like lip service galore. Oh, we have standards. Oh, we want this to be compliant. No, they didn't. It was garbage. It was just garbage. So we know that we needed to have a new organization, and we knew that we wanted to be focused on lead buyers because lead buyers have the clout in the marketplace. And of course, most of our clients are major lead buyers, not lead sellers. So we had great touches with great organizations that were willing to join. And so the premise is that you get a bunch of quality lead buyers who only want to buy the highest, truthful, transparent leads where consumers really know, hey, you're going to get phone calls and they're going to be about the specific thing that the consumer actually wants to hear about, so that every call that a Reach member actually makes, the consumer is actually waiting and expecting that call, right? That was the ambition, step one. So we wanted to make sure that all the bad leads were out of the marketplace. We estimated we could stop between 500 million and 1 billion unwanted calls a month. A month, just by cleaning up the bad leads that are out there, right? We obviously that was going to take time for the Reach model to saturate the market, but once it did, I really believe, still even now, that, that we will end up stopping about 1 billion calls a month. And we're looking forward to that. That was one part of the Reach model. The other part of the Reach model, though, of course, was to advocate to the commission, to the regulators, and especially the FCC, to try to get them to give leeway to good businesses in industry, basically, telling them, signaling and really expressly telling them, yeah, we know the lead generation industry has run amok. They've been terrible. They've been absolutely terrible. But there's a new sheriff in town, right? The solution is here. We're the cavalry. Just give us a little time. Let us get this cleaned up through regular market, movements. And unfortunately, right around the same time that Reach was created, of course, the commission came out with this NPRM looking at the lead generator loophole, as they framed it, really putting into stark contrast all of the misbehavior that the lead generation industry had been engaging in. And really, the commission decided it was going to take an incredibly aggressive stand, essentially looking to shut down the entire aggregator, the entire lead industry model, when it comes to both data leads and transfers. And so Reach all of a sudden had to pivot from an organization that was basically designed to set standards and bring people together behind, good practices, now to primarily an advocacy organization that was going to the commission and saying, please don't shut down the entire lead generation industry, and by extension, injure all of the good small businesses out there that rely on leads to survive.
And there's a ton of small businesses in this space. And that's something that I learned the more I got into lead generation, that, I had this preconceived notion that there were a lot of like most publishers were like giant companies, and that's just not the case at all, right? And so with Reach, transitioning, now obviously we have the second notice of proposed rulemaking, and the FCC is going to, vote on this at the December meeting, which is coming up here soon. I anticipate that they'll vote favorably on it and accept it. And I think that you've probably stated before that you view the same. And so how big of an impact do you think this rule will have? And how fast do you think it will have that impact?
Well, I mean, a lot remains to be seen. I think without question, the ruling is going to be adopted. Now, it has been brought to my attention that it's unclear in the wording whether or not this ruling will be immediately effective upon registration with the CFR, which is a position that I had been taking previously, or whether there's going to be a second comment period now, which is fascinating. This is fascinating. This was just brought to my attention today, so it's breaking news, that there may actually be a second comment period that runs after the open meeting, which, if that were to take place, would give industry a better chance to weigh in, and this time maybe they'll actually do it. So it's actually suddenly a little unclear in terms of how procedurally this is going to play itself out. But if it plays out the way I thought it was going to play out, and it still may, is the ruling will be adopted at the December 13 open meeting, and then it will be, the amendment to the CFR will be published in what's called the Federal Registrar after some, what they call, the Review of Paperwork Reduction Act requirements. Okay, it's so funny.
A lot of bureaucracy.
It's so funny the way the government works. And so that usually takes about 30 to 45 days. So you'd be looking at registration in the Federal Registrar or publication in probably January or February. And then the commission gave 6 months for the effective date. So I would anticipate that smart businesses are jumping on this right now. Right now, we're jumping all over this, right? Some businesses will say, and maybe rightly so, we'll deal with it in July of next year when this thing actually becomes effective. It does remain to be seen kind of exactly what industry's immediate response will be. I will say, I'm liaising with a number of companies right now, and obviously, what's not public record, I can't necessarily talk about, but I will say that industry participants that are large volume players, both on the buyer side and the seller side, are taking this incredibly seriously, and there's a lot of movement. I'm already seeing like mock-ups that people are dreaming up of what a one-to-one consent record might look like. So there's movement for sure. But setting aside the procedure, the substance of the rule is that now the lead suppliers can no longer do what they currently do, which is have thousands of people behind a hyperlink and then share the lead data of the consumer with, in some instances, hundreds of those partners. In many instances, they limit it to 5, whatever the case might be. That entire practice is gone. Now the commission requires a one-to-one consent, and that the consent be topically and logically related to the website. So rather than have a hyperlink with 5,000 people, now the consumer has to check a box that says specifically, I want to hear from your agency, and not from 10,000 partners that might be offering the same sort of insurance, which is really tough for small business, of course, because how do you have the market share to get yourself onto those websites? I don't know.
So if that does happen, I see it playing out a few different ways, right? A lead publisher on a website could automatically, dynamically populate, one particular company. Or you could give the consumer options of which company they want to select and check both. Is that true or not true? Do you have to give options, or could the publisher just give one option and the consumer, has to check that box?
But both are going to be available. So if the publisher has a form where it's like, get ready, we're going to connect you with the best person. Ta-da! The person that you've been connected with is Allstate, and maybe a specific entity that is a Allstate broker or an independent broker, whatever it is, that name populates, and beneath it basically says, click here to be connected and, accept all the TCPA disclosures. That is one model. Another model is that you're going to have 6, 7, or 8, 10, 20. It doesn't really matter, to be honest with you, how many show up in front of the consumer with little check boxes, and the consumer can check how many and who they want to receive messages from. Now, of course, I'm already being asked, can the check boxes be pre-checked? Can you have an option button that says select all, right? Can you do these things? And, my answer to all that, at least right now, is no, don't do any of that. No. Now is not the time to be aggressive, okay? Now is the time to be conservative and thoughtful if you're a lead seller. And if you're a lead buyer, you've really got to be vetting these forms. Again, you should always be doing that anyway. But moving into the new world, the plaintiff's bar is going to be going nuts. They're going to be going nuts over this. And so if you are being aggressive as a lead seller, I'm hopeful that there will be no market for your leads. If you are a lead buyer, do not just be driven by price. The fact that these ones are $1.50 and the other ones are $12.50 does not make the $1.50 one a bargain. It does not. It could actually make that lead the least attractive option by a mile. That lead might actually be worth negative $500,000, right? So you just really need to be thoughtful about your practices and recognizing, I just threw out 2 examples of like very low lead cost. Truthfully, I think the lead costs are going to be very high in the future for the good leads.
Yeah, and I think so too, right? Because if a publisher can't sell that, even if it's a legit publisher doing things what we would think of very, the right way, the consumer-friendly way today, and they're giving it to, let's say, 4 companies, right? A lot of insurance leads are sold, right, to an Allstate agent, a State Farm agent, a Farmers agent, and an independent agent, right? If you can't do that, right, and you can only sell it to one person, that's going to make lead costs go up. But I think it's going to make lead quality also go up because that consumer is not going to have 3 other people contacting it. So at the end of the day, this could be a good thing if you're willing to invest marketing dollars the right way and look at it and you can achieve a return on investment that's favorable for your business. This may be a good thing for consumers and for business potentially, if we have enough time to adapt and pivot and...
I mean, look, I can imagine a future world where this is not a bad thing. It's a bad thing only relative to our current environment where just so many people are going to lose their jobs. Yeah. And that's just a bad thing, and in my view, so many people are going to lose their jobs in an environment where the commission didn't try something less first. They leapt right to the hardest hammer that they had without really taking into consideration the impact on small business. And when you look at the ruling, I mean, they basically say that we reject any harm to small business. And I'm like, it's really too bad. So I agree with you. If we're going to be, Henry Kissinger just died yesterday, and he was the ultimate realist and pragmatic. The ends justify the means, right? No matter what those means might be. Yep. So if we look at it from that perspective, in a Kissingerian sort of way, the future world might be a better place. But the human capital and the costs of the marketplace, and really the collapse of the opportunities for small business to get there. I mean, it's basically like saying the world would be better off without small businesses or so many small businesses. And maybe that's true as an absolute, but man, I just don't feel that way.
And you don't feel that this solves the robocall, crisis in this country either. Do I have that right?
No, I mean, I'll put it this way. If everybody faithfully followed the law, we wouldn't have a robocall problem to begin with. And so, whereas I understand where the commission is coming from with this, the real impact will be on the legitimate businesses that want to do things lawfully. They will be out of business, right? As we've just discussed, or a large number of them will be out of business. Perhaps not all of them, but a large number will. And the market will collapse. And before that happens, though, small businesses that rely on leads aren't going to go out without a fight, right? They want to stay in business too. Half of them, maybe 90% of them aren't even going to understand that something changed, right? And so they're going to keep doing what they're doing, expecting it to be the same. Lead suppliers are going to know that. And the bad guys, right? I mean, I guess there's probably going to be some dumb lead suppliers that don't even know that the world changed, and they're selling to dumb lead buyers that don't know the world changed, and God bless all of them. Yeah. But there's going to be people who knowingly exploit the fact that people still want leads, even though it's illegal. And the ones that know what they're doing is illegal, well, now the genie's out of the bottle. Right? What we're doing is already illegal, so we might as well just go full Monty, right? And we saw what happened with the auto warranty schemes, right? When those guys decided, well, forget it, we're out of business no matter what, so we might as well just go for the glory, right? There was 300 million calls being made for auto warranties a day in this country when it was banned, right? And it's the same thing you're about to see. You take the lead generators and you ban the good practices, you make it impossible to be a good guy, and you squeeze all the good participants out of the market, well, there's no one left but the cowboys that don't care, right? If what they're doing is illegal anyway, there's the old saying, you can only hang me once, right? So let's just go for it. So I anticipate actually that this is going to end up being really bad in the short term at least.
So to pivot away from the new rules, a lot of insurance agents watch this podcast, and these are small business guys, right? And they may have, most of them probably have less than 10 employees, and they may or may not take the Telephone Consumer Protection Act very seriously today just because they don't know about it. And I think that, like, as a base level of understanding for them, why it's so important, because of the private right of action, but also because they can be held liable, even if they have their corporate business structure set up perfectly.
Oh, yeah.
So could you just explain why that's so important for them to follow the law?
Yeah, it's terrible. I mean, the TCPA is one of the few places in the law where your corporate form does not protect you, right? If you stiff a vendor, if you hit someone with a car, I mean, it's your business that's going to be sued. It's not going to be you personally. The guys working at Chevron that dump all the oil into the ocean, like they don't get sued personally, right? That's not how it works in this country. Chevron might have to pay a fine, but not you. Well, the TCPA is different. It is one of the only places in the law where you, as the person that works at the company, if you are the one on the phone making the illegal call, you can be personally sued. If you are, a CEO of a small company and you make decisions around what marketing you're going to do, and you're the one that decided, yeah, we're going to do some outreach, it doesn't matter that you thought what you were doing is legal. How crazy is that? It doesn't matter that you thought it was legal. Just because you blessed something that turned out to be illegal, you can be personally sued for your individual fortune, your bank account, your cars, your house. And it has happened to many people, unfortunately. Now, I think it's Bush League. Every time I see that, I want to strangle opposing counsel or the plaintiff that does that, because I just think that's terrible, especially when the company has money. Sure. But really, and this is really important for people to understand, I hear once in a while, most of our clients are not small business. We're fairly high in the market in terms of our costs. So most of our clients are larger companies, but we do have some small businesses. And, every once in a while, someone will come to me and say, hey, can you get this case settled? And just tell them, if they don't settle for nothing, I'm just going to shut down my business. And I'm like, well, you can shut down your business, but you're still going to get sued personally. Yeah. So there's no running away from this. It's not like you just, shut down your business, declare bankruptcy for your business, and you're out of it. If you're comfortable going personal bankrupt, okay. Although if the conduct that you engaged in was willful, I mean, I've seen plaintiffs argue that that's non-dischargeable. So, I mean, you really are talking about a buzzsaw that might follow you the rest of your life if you're not taking TCPA compliance seriously.
I think at the end of the day, too, it's the consumer experience, and if you're not taking TCPA seriously, you're not really respecting consumers. And does that put you in a good place for business? I think not.
I mean, one of the ultimate goals of REACH, right, is to become consumer-facing, to encourage consumers to work with brands that take privacy and contact preferences seriously, and to give them an objective measure of who those participants in the market are, so that consumers will gravitate, I believe, naturally to those brands. Now, if you are a small business and you're not going to join REACH and you want to still kind of differentiate yourself in the marketplace, there's other ways that you can promote the fact that, look, you're not going to be hammering consumers, but I mean, joining an organization like REACH is fantastic for you. It's like ready-made goodwill that you should consider. But the inverse is also true, which is what you're saying, which is even if you're not trying to, directly promote yourself as a good actor, you don't want to be out there establishing yourself as a bad actor in the market, right? Like if you're out there hammering people, not taking TCPA seriously, buying bad leads, harassing people, whether you intend to harass them or not, right? Because that's why I always hear, well, I'm not trying to harass anybody. I'm paying for leads that are consented. If you're paying 50 cents for a lead, man, you know you're buying junk. If you're buying aged leads, you know you're buying junk. And if you're hooking that up to an automated message and just hammering people, that's terrible for your brand. It's going to get you sued, but it's just terrible for your brand. Nobody wants that experience. So you got to be thinking about all these things.
It's a horrible consumer experience. And I think that the people who watch this, they want to be doing the right things. And it leads me to my next question, which is, consent on an internet lead form is good for 90 days under the TCPA. And a lot of agents that we'll talk to will say, all right, if I quoted Eric this year and, I say, hey, can I give you a call next year? When your policy renews, and maybe I can give you a better price at that time, and that person's on the do not call list, are they able to actually contact that person next year?
Well, I mean, it's going to depend on a couple of factors, but if all that happened is what you just gave me, then the answer is no. Now, if there was a transaction, if they sold a policy or something, then the answer might be yes, because you get up to 18 months. But, generally speaking, if you get an internet lead, you make the outbound call, you give them a quote, and they're like, not really interested. Even if you're like, hey, I'll call you back next year, it's not going to work. It's not going to work. You've got 90 days on that.
And I think that's actually going to be shocking to most people who are watching this, because I think that is probably a practice that many people engage in, and they don't think it's illegal, and they may not even be really faced with consumer resistance. The consumer's like, yeah, no problem. You're a nice guy. We talked for a long time. But, some of those people could potentially be also setting up a future lawsuit too, right? Because they know they can't give verbal consent.
And that's the challenge, right? So much out there, in this world, it's not common sense. It's not intuitive.
Yep.
It's not a moral issue, right? And so many times I hear people saying, well, I'm a good guy. I'm trying to do things the right way. I'm not trying to bother anybody. None of that matters, right? Like, the line between a good person and a bad person isn't drawn on the TCPA. Mm-hmm. The line between a rich person and a poor person is, okay? Mm-hmm. And that's what you need to be thinking about. These rules are hyper technical. They are totally unforgiving. There is no good faith defense. There is a strict liability statute. You either complied with it or you didn't, period, full stop. And as we already talked about, if you didn't, not only is your company in jeopardy, so are you. And that sucks. Like, I hate delivering bad news like that, and it's so stark and terrible, especially in the example you just gave where it's like, come on, man, the consumer wanted to hear from me. What am I supposed to do? But unfortunately, the answer is you have to follow the rules.
Right. And there are other ways that agencies could outreach to that. They could send direct mail. They could send email marketing. There are other things besides just the phone call to try and re-engage that consumer at the relevant time. But so it's not horrible, but it's at least we want people to really understand, like, that isn't an existing business relationship there. Just giving someone a quote, them not accepting them, right? Even if you just take the words existing business relationship, you didn't conduct business with them.
Unfortunately, the transactional EBR does require some form of, generally speaking, compensation. Technically speaking, it doesn't have to be compensation, but there does have to be a good or service provided.
So a lot of insurance agents too today, will buy aged leads. And you mentioned a few minutes ago, and I think it's a good segue into this topic. The price is very attractive. Yeah. But what's the danger from your perspective there?
Well, aged leads are incredibly dangerous. And there's a number of dangers. First of all, an aged lead, phone numbers change hands all the time, right? When you buy a lead for Bob Smith at this phone number, what you're buying is a phone number, okay? And Bob Smith may or may not own that phone number. Set aside the fact that if the lead is 180 days old, this guy's not even in the market for your product anyway. So, just set that aside, right? Even if you reach Bob, he doesn't want your product. You're paying for nothing, right? But it's just my opinion, but I think it's right. But if Bob, no longer has that phone number, then you're not even reaching Bob, you're reaching Jeff, right? Mm-hmm. And Jeff might be keen on suing you under the TCPA, right? Especially if that number is on the national do not call list. Mm-hmm. So you are walking yourself into a significant risk, even if you're calling manually, right, on this lead because of the recycled number phenomenon, because of the DNC. If you are calling a aged lead and you're not scrubbing the reassigned number database, which is a tool that you can use. If you want to buy aged leads, you should be using the reassigned number database so that you can avoid calling the wrong number, right? If you are buying an aged lead and you're not using the reassigned number database and you are using pre-recorded calls, for God's sake, you might as well just pack it up and just
game over.
You might literally just declare bankruptcy now. Like, you're done. The plaintiff's bar is so aggressively looking for pre-recorded call cases, and the strongest class action. I guess we haven't talked about class actions. We should talk about that. Because people might be thinking, well, so what? I make 1 or 2 calls using pre-recorded voice. Who cares? No, that's not the way it works. Unfortunately, in these cases, when you are buying aged leads using a pre-recorded voice, you're not going to get sued for 1 call or 2 calls. You're going to get sued for every single pre-recorded call that you made to an aged lead, period. So if you buy 1,000 aged leads and you make 2 calls to each, that's going to be 2,000 violations. And guess what? You're talking about $500 per call, right? So, even 2,000 violations times 500, I mean, how much is that? It's tough for me to do math. I'm not very good at math.
I'm not very good at math.
I think that's like 100K, right?
That's smart.
And people do these things at like much larger scale. And again, if you're really small, maybe you're not going to do too many. But if you're medium-sized or large, I mean, you might do 1 million of these a year, no problem, right? Think about the liability on that. It's massive.
Huge exposure. Yeah. And to get into class actions, I think a lot of the clients that we have that'll be watching this, a lot of the general insurance agents that watch this are probably captive agents, right? They're Allstate agents, they're State Farm agents, they're Farmers agents. These guys are independent contractors for those carriers, but the carriers exercise enough control over them and they only sell products for that particular carrier. Will you tell us a little bit about the vicarious liability for those carriers and how that might be pretty attractive in my mind to a plaintiff's attorney, because now it's not just Eric's Allstate agency, right? Now it's Allstate, a company that, generates, 30 or $40 billion, in revenue a year.
Yeah, no, you're exactly right. I mean, when these cases are filed, they're almost never filed just against Eric's Allstate company. That's not what it's about. Don't get me wrong, Eric's Allstate company will also be named.
Yep.
But Allstate, the mothership, is going to be named. And that's really what the plaintiffs' bar is after. They're when they file that lawsuit, it will be pled, at least, as everyone that Allstate or any of its agents has ever called using a pre-recorded voice, to an age lead or to a lead source. And so from the plaintiff's perspective, they're not looking for $100,000. They're not even looking for $100 million.
Yeah.
They're looking for billions of dollars, at least out of the gate. And obviously, these are shakedown lawsuits from a certain perspective. That's not to say they don't have merit, right? Sure. People get confused about this. They're like, oh, it's extortion. Oh, it's a shakedown. Yes, it is. But it's also a valid lawsuit, right? And you also have violated the law. And Allstate actually does have massive risk, as we've seen over and over again, which is why they've settled cases for millions of dollars repeatedly.
Yeah.
And it's not just them.
No.
Right? It's not like they're a bad actor in the space. No. Like, this is a phenomenon that exists out there, and not just in the insurance vertical, in all the other verticals as well.
And so that's really your area of expertise, is defending these big brands, these Fortune 50s, Fortune 100s against these lawsuits as they come up. And so oftentimes you're saying, yeah, maybe Eric's Allstate agency did violate the law. Maybe Allstate told them they shouldn't have engaged in that conduct. So, what's really what's the strategy to defend these? It seems like the law is really not on the side of the defendants in any meaningful way here. So it seems like a really challenging area of work you're in.
Well, it is a very challenging area of work. I mean, look, when you talk about complexity, so just understand, all of our cases are in federal court. Probably only 10% of lawyers in this country will ever practice in federal court. And we practice in federal court 100%.
Yeah.
And then out of that 10%, probably only 10% of lawyers will ever handle a class action, right? And so we are in that 1%. And not only are we in the 1% that has ever done it, it's all we do. Yeah. Which makes this an incredibly unique practice, and virtually no one does what we do. Billion-dollar cases, every one of our cases is a multi-billion-dollar case. Every one of our cases has the risk of shutting down even the largest enterprises in this nation. And when you talk about experience, knowledge, expertise, and the ability to get stuff done, there's no one that's done more of this than me. So the major brands are obviously attracted to that background. We are honored to help people in these lawsuits. And you're right, it is incredibly challenging. The substantive issues usually, not always, usually are against you. The plaintiff's bar is incredibly sophisticated. They make more money than anybody out there. They hire the best talent. They're very, very sharp. They're very aggressive. And they're smart enough to get rid of bad cases quickly. Mm-hmm. So the cases that we have, by and large, are the best cases that the plaintiff's bar has in the most complex environment, going against the best lawyers out there in cases where they want billions of dollars. And it's our job to stand in the way. Most of what we are able to accomplish, to get to success, we maintain a incredible record of success. I've been lead counsel in well over 500 nationwide class actions, and so far only one of those has ever been certified against me.
Wow.
And for a long time it was zero. I hate saying one. For a long time it was zero. But we're successful largely by really understanding how data works, how procedural law, like really esoteric concepts that most lawyers have never heard of and don't use day to day. We use that every day because those are the only defenses that are available to us. We really have to get the judges and their clerks thinking way outside of the box, really animating things. Constitutional issues come up in our cases all the time. We are, our firm in particular has created like more standing Article III constitutional standing arguments than I believe any other law firm. And we really help the law to develop, pushing those boundaries, creating something new, which very few lawyers do. I mean, most of the time for attorneys, it's just you do what's already been done, right?
Sure.
That's one of the unfortunate things about lawyers. That's why people are afraid that AI is going to replace some lawyers, and it probably will, but it's never going to replace us because we're not looking back and just plugging in formulas. We're looking forward and trying to see like where can we push for our clients to get a really good result. And like I said, we've had a tremendous track record. That's not a success, that's not a guarantee of future success.
Sure.
But we do deploy every strategy, everything that can possibly be done for our clients to succeed. And we read every case every day, and we share it on tcpaworld.com so that folks can have that information as well. But as you'd imagine, I mean, you take someone like me who's very passionate, very driven. We know everything about every case, and then we are creative and thoughtful. And we are going to be a very formidable foe for anybody. Even if the deck seems to be stacked against us, we still seem to find a way to win.
One of the first times I saw you speak, I was fascinated because you didn't come off just like a lawyer. You were extraordinarily passionate about what you talked about, but then you also were talking about computer code in your presentation. And, having you saying, I actually review computer code to see if there's a randomizer in. And so this is all in the details. Everything is in the details in what you do. And I think, that's something that differentiates you probably from others in your peer group. Is there a lot of people who practice defense work to TCPA litigation?
Not at the level that we do. Mm-hmm. And I always tell people, the clients can smell a phony a mile away. Mm-hmm. And there's plenty of phonies out there. Guys that have been doing this for a year or less or 2 years or less, they're just like, hey, I do other sorts of stuff for you. Yeah. I can handle this. And of course, and that's one of the problems with big law, right? Their model is you get paid to con clients into thinking that you or your partner can handle something that they can't handle, right? That's not our model. Our model is, this is all we do, and we do it at the best possible level. We are completely saturated and absorbed by it. And so if you need this, we are here for you. If you need anything else, sorry, we can't help, right? And we don't hide from that. Right? And that's the problem with the big law model, is they can't say those words, right? They are compensated. There's pressure on them to cross-sell and collaborate, which is just code for tell your clients whatever it takes to get them to send that case to you. So you're going to see a lot of phonies. Now, there are a couple of firms that do this, that know the law. They all follow TCPA world. They all walk behind me. But you know what? That's okay. Right? That's okay. They're following the right person, and they're doing things the right way. And so there are other firms out there that I would say are capable, but nobody blazes the trails that we do.
Yep. And so you talked about constitutional issues, and that got me thinking about, when I talk to insurance agents today, one of the biggest concerns that they have is, are their phone calls actually being delivered to the end user? And, I think that we've discussed this before, or I've read it on TCPA World, but, it seems to me that there's a pretty big constitutional issue there in the government blocking communication between parties, right?
It's ridiculous. It makes me, nothing makes me angrier than when I talk about carriers call blocking. Mm-hmm. And, especially for a guy like me, I'm not as young as I used to be. I remember the old days as a telecom lawyer. You go, and by old days, I mean 6, 7, 8 years ago, right? And carriers in this country were common carriers. For 80 years, from the creation of the Communications Act back in the 1930s, every single call that was made in this country would be faithfully connected. There was never a question about that. You want to call, to put in a hit on a mob boss or something, that call's going through, man. No one's going to stop your call, no matter what it is for. That call is going through. That was one of the superpowers of the American economy. It was one of our superpowers of our infrastructure. Our telco infrastructure was that it doesn't matter who put in the line. It doesn't matter who owned the cable. That call was going through, right? That all changed in 2015 when the FCC first allowed opt-in call blocking, and the carriers were freaked out. They're like, what do you mean we can block calls? No, we can't. For 80 years, we've not been able to block, regulate, segregate, change, toll, nothing. We could not touch anything. And now, at a left field FCC, you're saying we can? And that led to a bunch of proceedings. And then in 2018, the FCC said for the first time, not only can you do it on an opt-in basis, you can do it on a default basis, meaning you carriers can use reasonable analytics to block and censor communications at your own discretion without accounting to anybody. And it was the biggest change in telecom law in this country ever. And nobody talked about it. I did, but nobody else talked about it. And even then, this was 2018, the carriers were very uneasy, and they kept going back through their trade organizations to the commission, asking for, further explanations, for safe harbors, for protection. And the FCC has responded now in 4 different orders saying, yes, you can. We're going to give you safe harbors if you do it reasonably. We're going to protect you. We're going to make text messages not even subject to the Communications Act at all by saying that they're information services and not telecommunications. Like all these wonky rulings to give the carriers as much power as they possibly can. And the carriers have now responded as state actors, in my opinion, and do, what the FCC has basically mandated that they do, and are blocking calls at times seemingly randomly, right? Using some analytics that are black box algorithms that nobody knows what they're doing. And at times, very deliberately on a content-specific basis, for instance, targeting any debt relief company right now and preventing their text messages from going through. I mean, that is just flat unconstitutional. You're using a content-specific basis to remove free, honest, truthful speech, which is constitutionally protected, from the waves because you're just choosing to do that? Oh my Lord, that is so unconstitutional. It's a flat violation of the First Amendment. It's a licensing scheme under Supreme Court law. And I cannot wait for that entire castle built upon that sand to implode.
So even with that happening, it still hasn't solved the problem.
No, of course not. It's garbage.
So what is going to solve the problem?
Well, so I've put forth on TCPA World what I think is a three-part solution to the robocall problem. And it comes from recognizing that there are three major drivers of unwanted calls, right? The biggest driver, in my opinion, is, of course, offshore scam calls, right? And the reason why those have never been effectively blocked or stopped is because there's no law that says the carriers can do that. Now, the FCC has, of course, said you can do whatever, but that's not the law. The Congress gives the law, right? Congress has only enacted the TCPA. The TCPA only looks at callers. Well, here, the callers are outside of our jurisdiction, so we don't care about the callers, right? I mean, the callers don't care about us, I should say. They care about our money. They don't care about our laws. What Congress has to do, and has never done, is pass a law instructing or empowering the carriers to not carry international traffic pursuant to certain parameters, right? And those parameters can be established by the policy of the government, or it can be established by the FCC. I don't care, but they need to be clear so that people actually know what the rules are. Right now, no one knows what the rules are. So that's the foreign traffic. That is why it's just crazy that we don't have a law on the books that says carriers can and should, and here's when, block foreign traffic. It's just nuts that that's the case, but that's the case. The second piece is, of course, the lead generators. We've talked about that. 1 billion calls a month we could stop, and that's a huge amount. And there again, the FCC has swung and missed, because rather than regulate in a way that gives the industry breathing space, right, to be able to act in a legal manner that's transparent and good for the consumers, they've gone and basically chopped off arms and legs and made it so only the bad guys are going to be out there just on a free-for-all. And of course, the carriers might be blocking some of this, but they're acting on an ad hoc basis using algorithms that shift every day based upon like who's sitting at the switch that day, pretty much. So it's a mess. It's a mess. And these messages are going to get through, just like the auto warranty messages got through, even though default call blocking was in place back then too. Didn't stop them at all, right? It might stop some, right? I mean, maybe the carriers were like, aha, it wasn't, they sent 400 million and you only got 300 million, so pat yourself on the back. I mean, okay, but it would be great if those 400 million were incentivized to exist to begin with, and carrier call blocking is not going to be that solution. And then the last piece of the unwanted calls in this country are calls that are legitimate calls, but are just intended for somebody else, right? The wrong number call. You got a new phone number, or somebody put in the wrong number when they filled in an application or a form, and now you're receiving calls that are intended for somebody else. And there are solutions for that. One of them, of course, being the reassigned numbers database. And also there's vendor solutions that will help you to predict whether or not you might be calling a wrong number. So, and again, even though those solutions exist, guess what? No one is legally mandated to use them.
Yep.
Isn't that crazy?
It is crazy.
I mean, the reassigned number database, if you're not required to use it under the law. It's just bizarre.
It's very strange. And I think you brought up a great point, and I think that folks probably will be shocked by this, but if I filled out a lead gen form with all of your information today, and I submitted that, and, Susie's insurance agency calls you, that's an illegal call,
Yes,
right?
it is. Susie, I could sue Susie, and Susie would have no recourse. She'd have to try to go after you, and she'll never find you. And that's the problem with third-party leads, right? Even first-party leads can be very problematic.
Sure.
I mean, that's the ultimate hole in the lead generation model, is you never know who's behind that computer screen. And if you call a lead in complete good faith, that is not a defense for you if ultimately you filled out my name without my permission. Now, if you did it with my permission, that's different.
Different. And it's going to be very hard for that person to trace back to me, even if they have an IP address, even if they have anything else. They can't prove that I was at my house, at my computer doing that. There's going to be a lot of issues. But so there's risk. I mean, would you classify that as a defect in the law? I mean, what would your solution to that be?
Well, no, that's a defect in the fact that, internet activity remains anonymous. Now, the day might come when we all take our thumb and put it on some pad and log in and register, using our biometrics so that everything we do in the internet session, it can now be attributed definitively back to us. And when that day comes, that flaw in the central concept of a third party or web form lead will be alleviated. Until then, that is a problem. And the FCC, implicitly, not expressly, implicitly has said that problem means that we don't like online web form submissions at all. And that's one of the things that is driving their one-to-one rule, right? Mm-hmm. It's basically they're willing now to overlook that problem in the context of one-to-one because the damage that can be done in that context is now lower. But that was one of the very first things I remember many years ago. I was talking to the commission in connection with a totally different proceeding. And there was a staff member that asked me directly, because of this, because you never really know who's on their side, why should we allow there to be online leads at all? And that was a question that was posed back in 2017, I want to say. That was 6 years ago. Yeah. So that's always been percolating in the back of the commission's head, which is if you can't validate who's submitting the lead, why are we allowing these?
And I suppose you could validate a little bit with a text authentication or something like that, right?
Yes.
That would be that's probably the ultra safest way.
Well, I was surprised that was never brought up in the proceeding, that the commission didn't propose that as a potential solution. Mm-hmm. And obviously one of the reasons you don't want that is, you don't want a bunch of misdirected MFA attempts either. Mm-hmm. But I mean, it certainly would slow down, future messaging mm-hmm. and limit, at least in the first instance, the number of calls that might go out.
Mm-hmm. One thing I wanted to touch on was what constitutes a do not call request from a consumer.
Okay.
And I think that can be a challenging question for you, especially if you have a consumer on the phone and they say, obviously if they say never call me again, that's pretty clear. But if they say, I don't want to talk to you and then hang up, is that a do not call request? What's and I get that it's tricky, but what's your advice to folks? Not friendly advice, not legal advice to
That's right.
clients.
That's right.
But, what would your friendly advice to someone be on that topic?
Well, I can talk about it at a high level, which is the law is somewhat favorable on that. And consumers have to expressly and clearly state that they desire for messages to stop. So, the example of don't call me anymore, obvious. The example of the other extreme is I'm not interested. I'm not interested. The courts have been very clear. That's not a DNC. You do not have to a person who just says, I'm not interested on the DNC list. Conversely, I don't want to talk to you. Is that a clear statement that they want messages to stop? Probably not. But if you're operating safely in an environment where you want to take consumer contact preference seriously, that's definitely somebody I would put on my DNC list. Mm-hmm. Whether or not you technically had to, I'm not sure, but you don't want to ride that line because mm-hmm. one, even if it's not a litigator, that's someone that doesn't want to hear from you. Mm-hmm. So just leave them alone. But if it is a litigator, you just bought yourself a lawsuit, buddy. Mm-hmm. Even if you might ultimately through, powerful and expensive defense lawyers like me, win that case, that's not a good investment of your time or money.
And probably leads to some potentially sleepless nights given the ramifications and the personal ramifications in this area of the law.
And my invoices.
Exactly. And, I think that it all comes down to consumer respect and respecting the consumer's choices. And with that said, really my final question to you is, on a lot of the insurance lead gen forms, it seems to me when I go through them that it is showing you're going to get a quote. And I think that the consumer believes they're going to get a quote in an online bindable fashion.
Yes.
And that doesn't happen. Do you think that then consumers are surprised by the phone call?
For years, I have been advocating that big players in the market, the lending trees and the Lower My Bills and others, had to take a look in the mirror and when they would talk about reducing friction in the funnel and encouraging engagement, at what point are you not removing friction, but you're falsely bringing people into an environment with false hopes? And I'm not saying that they do that, but what I am saying is if you're buying a lead, you need to do more. And I'm sorry to give you even more homework when you're buying a lead, but you need to do more than just look at the disclosure. You need to do more than just make sure that the Troutman 9 is on the form, or that in the new environment it was a 1-to-1 consent. You need to look at the entire flow to understand what was the consumer told that brought them into this ecosystem, that brought them to the point of agreeing to the consent. Because to your point, if they're told, click here to get quotes, and all they get is an ad for Quicken, I don't know, man. That might not be a binding consent, and it might be fraud.
Yep.
And again, I'm not saying it is, but that's definitely something that folks need to be looking at.
And REACH the REACH standards will help here. And
absolutely.
Insurance agents, I'm saying right now, insurance agents should join REACH, right? Responsible Enterprise Against Consumer Harassment. Insurance agents want to talk to people who want to talk to them, who are interested in, potentially, saving money on insurance and buying a policy. Insurance agents don't want to waste their time or money talking to people who don't want to be, talked to about this. And joining REACH, right, there are clear standards for publishers. There are clear standards for lead buyers and what you can and can't do, and driving in my mind, a responsible and reasonable and rational approach to consumer contact.
That's what we're aiming for.
So how can folks join REACH should they want to?
Well, they can visit REACH MBC, that's REACH, MBC Mutual Benefit Corporation, reachmbc.com. They can also reach out to me or to Jennifer Cabrera of my office. We're easy to find on the internet.
And everyone should also visit regularly tcpaworld.com, right? Eric and his team do a great job of this free resource.
Totally free, no barriers, totally free.
Totally free resource to learn a lot about marketing compliance, learn a lot about the Telephone Consumer Protection Act, learn a lot about the changes that are coming, and potentially more changes. Do you think any more changes will be coming in the next year, besides these big ones that the FCC is looking at right now?
I don't. I think we have our mouths full, so to speak, and we're not going to cram any more in for right now. I think for the next year, everyone's going to be digesting what the commission just did. I think the commission is going to be looking to finalize its rules and looking to move off of this issue.
Yeah.
They've got net neutrality on their plate. They've got quite a few other things on their plate. I think the FTC is likely to be more aggressive, and the DOJ is likely to be more aggressive, but not changing rules, just enforcing them. So I think that the good news is I don't see any other massive mind-altering changes on the horizon just yet.
Well, that's good news, and we have a lot to get through in the next several months and figure out how to pivot and what's going to happen. So thanks for having us here. Thanks for taking time to educate our audience on the importance of the TCPA and marketing compliance generally.
Yeah, absolutely, man. Yeah, I love what you're doing, and keep it up.
Thank you.
Yep.